Welcome back to the Weekly Friedman, your source of the most essential information in the default industry. Today, we're focused on evictions, more specifically, New Jersey and New York evictions, how they're similar and where they differ. I'm Adam Friedman, managing partner at Friedman Vartolo, and helping me work through this topic is Friedman Vartolo attorney Richard Tracy. Richard has extensive experience handling landlord-side evictions in both states and has a wealth of knowledge on eviction law in general. How's it going, Rick?
Very good. Happy to talk about one of my favorite topics, which is New Jersey, how New Jersey runs things, but also how it compares to New York.
All right, so Rick, let's jump right in. Let's start with New Jersey. Walk me through how this goes. When you have to evict post foreclosure, is that something where the eviction legal process is taking place in the same case as the foreclosure action, or is it a new case?
Most of the time for us in New Jersey, we're actually using the foreclosure judgment and what we already won in a foreclosure judgment in order to remove any occupants that are there. In every New Jersey foreclosure judgment, there is actually a phrase that says, whoever wins at the sale has the right to take possession against the former mortgagor and anyone else who's there. There's a landmark case in New Jersey. It's the Chase versus Josephson case, where they said that the exception to this is if anyone's a tenant, then they cannot be removed by this process. You have to start a fully fresh and new thing.
Does that mean then if a third-party bidder wins at the foreclosure auction, they can also use the bank's foreclosure case to then evict?
Yes, they could. So they would have to appear, and it's almost like a denouement to the foreclosure case where they would come in and say, hey, I'm invoking this right that was awarded. I am this person that should be given this power.
Is this the same process in New York?
So New York technically does have something similar. So New Jersey is called a writ of possession. In New York, it's a writ of assistance. However, New York, and this is sort of like a general comparison between New York and New Jersey, that New York is a lot more stringent in how they approach. So actually, a writ of assistance is usually not that helpful, because if there is anyone that was not included in that New York foreclosure case named as a respondent or a defendant, then you cannot use that writ of assistance against them. Versus in New Jersey, writ of possession is actually powerful because it's anybody that they discover at the premises, with the exception of tenants.
Is this very helpful in New Jersey? So the fact that you can go back to the foreclosure action, is that a big time saver?
Oh, yes, 100%. So even with the relatively quick landlord-tenant process in New Jersey, a writ of possession is much faster, much easier, and ultimately much cheaper. We just have to make a simple application to the court. It's not even a fully fledged motion. It's we apply saying, hey, the judgment said that whoever wins can be awarded possession. And number two, we won. Here's a copy of the deed. And then the court will review it. They'll issue that warrant relatively quickly, usually within a couple of weeks. And then you take that to the sheriff, and 30 days out, typically, you'll have your eviction date.
When you think about an eviction to an outsider, to somebody not practicing eviction law, it almost seems simple. It's like, look, we have someone living in our property. We're the owner. We should gain full control of the property. We want somebody evicted. But I know that in each state, New Jersey and New York, it's a much more complex process, and there's much more procedurally going on. So would you mind walking us through that procedural process in each state?
So in New Jersey specifically, if we're doing a writ of possession, what usually happens is someone might come forward. So we schedule a date. The sheriff goes and posts the warning saying, hey, we're going to evict in 2 weeks. Usually that brings people out of the woodwork. They might file an order to show cause, then we'll be brought in. If it's the former mortgagor, sometimes they ask for essentially a sympathy stay. They might say, it's hard to find a new place. Can I get another month or two? And the court will award them maybe 1 or 2 months, depending on the situation. However, sometimes we have someone come forward and say, hey, I'm actually a tenant, and here's my lease, and I used to be paying, in which case the court will be like, oh, okay, actually, you're a protected tenant. You cannot be evicted in this way. And that's one of the complications that we see in New Jersey, where there's 2 separate pathways. But because we have limited information on the physical, who's physically there at the property at the end of the foreclosure, we often don't know exactly. And sometimes we only find out late in the process that actually we have to shift gears and go from a writ of possession to an actual fully fledged landlord-tenant separate case, because it's a protected tenant here.
Okay. And what about New York?
So in New York, because the writ of assistance is usually not so good, we use New York's pathway, which is an eviction. We'll do either a 10-day notice to quit or a 90-day notice to quit for a tenant, and then bring it as an eviction in whatever special localized court it is. And New York being very non-standardized, it's actually very different if you're in New York City versus Long Island versus upstate. New York City, they have their own special housing courts that specialize 100% in this. In Long Island, there's the district courts. And then upstate, you actually have this all being brought in what's essentially a municipal court, and a local municipal judge who might not have much specialized knowledge in housing and eviction will be deciding your case. And that's why we see very varying outcomes and timelines upstate, because you never know what you're going to get with these local places.
Okay. So look, I think everybody knows that there's a stigma in New York that a New York eviction takes a really long time period. Is that true? Like, how does the timeline compare between New York and New Jersey?
Sure. So when you have a tenant in New Jersey, we have to bring a separate case. It is very quick. So New Jersey truly treats it like a summary proceeding. Both states consider it a summary proceeding, which means in legal terms, it's a one-time go, quick, have it all out in one quick action summary. New Jersey truly does treat it like a summary proceeding. You literally file your case, the court serves it for you, you go in for one trial date, literally one day, you go in, and you'll have the trial on that day, and the case will be disposed 99.9% of the time. That's New Jersey, and it'll be done in about 3 months. New York, there's a lot more going on. So New York City specifically has a much longer timeline. Number one, you're going to have to serve the notice to quit and serve the petition. That's going to take time because sometimes people avoid service, and that just brings its own timeline issues. And number two, the courts themselves are extremely overloaded because the process itself in New York City, a single case can maybe have half a dozen appearances. And so their calendars are overloaded in Kings just from filing to initial hearing. Because they're so overloaded, it's about 6 month to 7 month wait just going from filing to getting your first hearing, which is just the beginning of the process. And so, yeah, there's also other issues going on. We don't deal with it as much, but those housing courts are dealing with complicated issues like rent control. They have their own judge shortages. And also in New York City, most people know it's a very tight housing market. So whereas a lot of cases will, be settled out because you can pay them to leave, or sometimes people just leave on their own because they find a new place to live. In New York City, the housing market is so tight that these cases aren't solving themselves, and it takes a lot of money and a lot of resources to reach a settlement that makes it feasible for someone to move out in New York City.
Do you think the reason New York has a longer timeline is because of the judge shortage, because of the law, or both?
Yeah, I think both. It's an amalgam of a lot of issues. The complex legal environment, because there's many renters, many laws protecting renters, and the housing courts have to deal with that. It is the judge shortage. But to some degree, I think it's also the culture as well. I think the overarching environment that they're in is to be pro-renter, pro-tenant, just because they're a huge constituency and a huge part culturally of New York City. And so they're going to be more sympathetic to a judge, I think, than in New Jersey, where the judges, they'll even express sympathy in New Jersey, but they'll say this is the law. The law is very straightforward on it. And, even if it's not sympathetic, we have to go how it's actually written.
To recap, evictions can be extremely state specific. Timelines and process can vary widely by state, and it's important to fully understand these differences when projecting a timeline to possession and the cost associated with gaining possession. Thanks for joining Richard Tracy and I on the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.